I want to scroll through the screenshots for burden of proof affirmative defenses, and either in this recording or the next one, justification or the defense of justification. I thought it would be useful to elaborate on some of the points, highlight some of the points. Let's start with burdens of proof. And again, we're talking about a criminal case. And in every criminal case in New York, as well as every other state in the Union and the federal courts, the government, the prosecution, has the burden to establish beyond a reasonable doubt every element of the offense or crime charged. And that never changes. In fact, the Supreme Court of the United States has held that beyond a reasonable doubt standard is a constitutional requirement under due process of law. Now, what happens is there's a burden possibly imposed on the defendant if the defendant raises what's known as an affirmative defense. And we'll be talking about that in a bit, but what I want to point out is that even if the defendant undertakes a burden by raising one of the affirmative defenses, the prosecution is never relieved one bit of its obligation to establish every element of the crime charged beyond a reasonable doubt. And many years ago, I assisted a judge presiding over criminal cases and putting together charges to the jury. And if there was a case in front of the judge involving an affirmative defense, then the charge would be something along these lines. The judge would tell the jury, here are the elements of the crime. The prosecution has to establish every element beyond a reasonable doubt. If you find that the prosecution has done that, then the judge would say, I instruct you to consider the defense raised by the defendant, which is an affirmative defense in this case, and for the defendant to prevail on the defense, the defendant must establish the elements of the defense by what's known as a preponderance of the evidence. And I'm scrolling down and you'll see that in page 2. The other thing I would say generally about burdens of proof, there are some defenses that are not affirmative defenses, and I've labeled those defenses as regular defenses, simply to distinguish them from affirmative defenses. And the regular defense that we are going to study is justification. Of course, the large part of justification is known as self-defense. So, if the defendant has raised simply a regular defense as opposed to an affirmative defense, then the burden will be imposed on the prosecution to disprove the elements of the defense beyond a reasonable doubt. So, sort of to summarize, prosecution always has the burden beyond a reasonable doubt. If the defense raises an affirmative defense as to that defense, the defense must establish it by a preponderance of the evidence. If it's a regular defense, such as justification, then the prosecution has the additional burden of disproving the defense beyond a reasonable doubt. I think it's fairly clear, just a lot of words to get there. So let's talk about, there's 3 affirmative defenses that I've identified. We've looked at the penal code provisions, I hope. And in the order I have them in the posting, there's the affirmative defense of insanity, which is sometimes known in New York as mental disease or defect. The one takeaway I want to give you at this point, other than what I have, let me resume. And again, I apologize, but I'm working at my law office, and this as I've said before, there's incoming from time to time. So the takeaway on the affirmative defense of insanity is that the defendant, because it's an affirmative defense, has to prove two items, not just one. First item the defendant has to establish is that at the time the crime was committed, the defendant was suffering from a mental disease or defect. That alone, however, is not sufficient. The defendant also has to establish, and this is where it gets dicey for the defendant a lot of the time, that because of the mental disease or defect, the defendant didn't know right from wrong or couldn't appreciate the nature and consequences of his conduct. And oftentimes in a criminal case, in New York at least, where the defendant has raised insanity, all of the psychiatrists offering testimony for both the state and for the defendant agree that at the time the crime was committed, the defendant was suffering from a mental disease or defect. But the difference is whether or not that mental disease or defect stripped the defendant of the ability to be cognitively aware of what the defendant was doing. Wisconsin has a defense of insanity very similar to New York's defense. And you may have heard of Jeffrey Dahmer, the guy who killed people and sexually molested them and ate them, and maybe in that order. But in any event, he stood trial, and I believe all of the psychiatrists who testified said this guy is crazy when he committed these murders. But the difference was the prosecution psychiatrist said he knew what he was doing, nevertheless, and the defense psychiatrist said that he didn't know what he was doing, and if you remember, he was sent to prison because he was convicted. In other words, the jury rejected his defense. And I think if you think of Dahmer, and maybe other types of those situations, oftentimes the person, as in Dahmer's case, tries to hide what he was doing. In other words, Dahmer wasn't driving around Milwaukee, Wisconsin, with dead bodies strapped to the top of his car like he was a hunter. He was hiding them, and the fact that he was hiding the corpses of his victims would indicate that he knew what he was doing was wrong. Scrolling down to the affirmative defense of duress, this defense is only going to come into play if there's a threat of imminent unlawful physical force or the actual application of unlawful physical force. And usually, and then the defendant, because of the threat or the application of the force, commits the crime. And what I'm going to tell you is that if this should happen, there's probably going to be a prosecutorial decision not to charge the defendant in the first instance. So we don't run into this defense a lot. I would point out that it requires the defendant be subjected to unlawful physical force or the imminent threat of unlawful physical force in a straight-up blackmail situation where the defendant is threatened simply by the disclosure of embarrassing information, even though that may be quite compelling in some instances. That's not going to constitute the defense of duress. Now I'm going to the third defense, the affirmative defense of entrapment. And several of your classmates have sent me some very good questions about the defense of entrapment. Let me say that typically the defense of entrapment isn't going to be available to most defendants. If you look at the traditional police work, what the law enforcement would tell you is that there are crimes without a victim that is going to report the crimes. Notice I'm not saying victimless offenses, because I think some of these offenses, drug use, prostitution, the victims are piled high. But certainly people don't walk into the police station and say, somebody just sold me some heroin, or walk into the police station and say, I just want to let you know that I paid money for somebody to provide sexual services to me. Or back in the day before we had a lot of legalized gambling, people weren't going into the police station and saying, I just want to let you know I have a bookie who takes bets from me. So what law enforcement will tell you that for crimes of this nature, to ferret them out, what they have to do is basically give a person an opportunity to commit the crime, and that's okay. When I say that's okay, if you look at the 40.05 of the penal law, what it tells us is that simply giving a person an opportunity to commit a crime, and then the person commits the crime because they avail themselves of that opportunity, is not the defense of entrapment. I always kind of smile at this memory, but when I first came to Buffalo many years ago, and I was working for a judge who was handling felony cases, and in his courtroom sometimes there would be undercover cops offering testimony at trials or hearings regarding the sale of drugs, and I'd be sometimes hanging out in the back of the courtroom. They wouldn't obviously give me any notice, and so the day comes when I walk into a bar in Elmwood Avenue. You sit down, I was watching a ball game or something, and one of these guys who's like one of these undercover agents, he strikes a conversation, and then says to me, not knowing that I work for the judge, hey, do you have any, I forgot what it was, but he was looking for cocaine or pot. And of course I said, no man, I didn't. And if I did, which I didn't, I wasn't going to sell it to him. But had I done so, that would not have been a good defense of entrapment. So what is a good defense of entrapment? Well, not only do you have to show that you were given an opportunity to commit the crime, defendant, but you also have to show that the methods used to obtain evidence against the crime created a substantial risk that the offense would be committed by a person who was not otherwise inclined to commit the crime. So if you're arguing this on behalf of a defendant, what you're basically saying to the jury is, you would have committed the crime too had you been given or if you had been subjected to the methods that the government used to lure the defendant into committing the crime. And most of the time, the jury's going to say, I wouldn't have sold drugs, or I wouldn't have patronized that woman who was pretending to be a decoy, or pretending to be a prostitute, in other words, acting as a prostitute. And there goes the defense down the drain. Now, I didn't put this in the posting, but to respond to one of the students, certainly there's been instances, and I know I did some work along these lines back in the day regarding the government seeking to create or investigate, better said, not create, investigate political types of violence. And the concern was there that the government would actually manufacture the crime. And I know that I was involved tangentially in some cases where you had guys who were posing as Vietnam veterans. So this would have been in the late 60s, early 70s. And they would be older than some of the students in the college campus, and they'd be rousing them up and say things like, it would be a good idea to go bomb the ROTC office. It would be a good idea to, commit some kind of act of violence